This video will be analysing the 1765 case of Entick and Carrington. And this is a case that's reported in a number of places, but for the sake of this analysis, I'm going to be relying on the law report in the State Trials collection. I do that because I think it's the most comprehensive of all the reports, and for this reason it's the one that I provide the link to on this website here. Now, the headline for the case is that, albeit over 250 years old, Entick is a key constitutional law case, and it's particularly so for its relationship to the rule of law. And here specifically it's because of its coincidence with Dicey's second characteristic of the rule of law. Now, you may recall that Dicey identified three characteristics for the rule of law, and the second of these was as follows: no man is above the law. Every man, whatever be his rank or condition, is subject to the ordinary law of the realm, and amenable to the jurisdiction of the ordinary tribunals. And Entick can be used as legal authority to support this proposition. Now, when Dicey started writing, he did recognise the case of Entick, but he didn't give it huge prominence. In his work, it started out as a footnote to support that characteristic in some way. But over the years, it's been given greater prominence, and for example, Sir William Wade has described it as perhaps the most important of all cases. It's a case that enjoyed its 250th anniversary in 2015, and at that time Adam Tompkins and Paul Scott produced a collection of essays on the case. And so if you want to look at it in a deeper sense, you can look at that collected work that is published by Hart and is entitled Entick and Carrington, 250 Years of the Rule of Law. Now, if we turn to look at the case itself, first it's necessary to set it against the politics of the time. And, like with the recent Miller case, for example, political context is all important in appreciating the decisions that are made in constitutional cases. So if we look at the 1760s, George III is on the throne, and he and his government face criticism, particularly in the form of newspapers and pamphlets, and these are becoming more and more readily available at the time. Now, the government regarded these publications as libelous, and indeed the phrase that's used in the judgment is that of seditious libel, and here the word sedition means promoting insurrection against the government. And Entick becomes one of a series of cases involving the government response to this alleged sedition. Other examples are the cases of Wilkes and Wood and Leach and Money. Now, that case of Wilkes that I just mentioned is particularly important from this series for its prominence in the lead up to the American Revolution. And you can read more about that elsewhere. But if we look at Entick, this also has some relevance to what happens in America, because here Entick becomes a link to what then becomes the Fourth Amendment to the United States Constitution, which is the protection against unreasonable search and seizures. In the United States case of Boyd and the United States in 1886, the Supreme Court said that Entick is a great judgment, one of the landmarks of English liberty, one of the permanent monuments of the English Constitution, and a guide to understanding what the framers meant in writing the Fourth Amendment. So you see that Entick gains huge prominence, and in particular it appears to have recognition across the ocean in America. And one of the reasons for this is that is the sentiments of discontent in Britain in the 1760s are being echoed in the colony of America at the time, and their shared this shared dissatisfaction ultimately is part of the driver towards the American Revolution. But if we come back to Britain. We look at John Entick, and he was suspected of being the author of an allegedly libelous pamphlet entitled The Monitor. And the Secretary of State at the time, the Earl of Halifax, sent a number of men, including Carrington, to Entick's home in order to search for and, if found, seize particular items in Entick's house. Now, as a result of this, Entick, who becomes the plaintiff, sues Carrington and others for trespass. Now, what we want to note at this stage is that whilst the case has constitutional law implications, it differs somewhat from modern cases of judicial review, for example, such as Miller, because it's a private rather than public law action. It is, in effect, an action in tort for trespass. Next thing we need to identify is the third key actor in the case. So we have the plaintiff, we have the defendant. But the judge is the Chief Justice of the time, Lord Camden, and he goes on to find in favour of the plaintiff, Entick, and he awards damages to him, as one would expect in a case of trespass. But importantly, for consideration of the context of the time, Lord Camden is also a judge in some of the linked series of cases, such as Wilkes and Wood. Now, if we look at what the judge had to decide, Lord Camden had to decide whether there was any legal authority that would provide a defence to this allegation of trespass. There was no dispute that Carrington and the men had done what Entick had alleged. The question became whether they had any lawful authority for entering his property and behaving in that way. Now, the defence was based on the fact that the Secretary of State had issued a warrant that granted authority to Carrington to carry out the actions that he did. Now, this being the case, for there was such a warrant, the court had to consider the validity of that warrant, namely whether the Secretary of State actually had the power to issue the warrant. Now, it's often said, of course, that the government only has power to do what the law allows. And here we see a link to Dicey's second characteristic and the court considering this suggestion that the government only has authority to do what the law allows. Now, the Secretary of State claimed authority to issue the warrant from at least two sources. Firstly, statute, and secondly, common law. And he also added, by way of argument, the suggestion that it was necessary for the ends of government for him to have such a power, and I will deal with that towards the end. So the first thing that the judge had to do was to look at the statute. He looked at the statute and found that the power to issue warrants only resided in a justice of the peace. And whilst the Secretary of State was a powerful person, his office was not that of a justice of the peace, and he had no authority to issue such a warrant. And therefore the judge found against him on this point, so strike one against the Secretary of State, or in effect Carrington. On the second point, the Secretary of State claimed that he had a common law authority to issue these warrants. They had been in effect issued by Secretaries of State since the Revolution. And when this claim was made, the term revolution, of course, means the Glorious Revolution of 1688. And here, firstly, the judge found that the common law didn't begin with the Revolution. He also said that anything starting in 1688 is too modern to be considered law. He actually went and looked at the common law and found that it contained no power for the Secretary of State to issue such warrants, and in effect identified that just because something has been done historically doesn't mean that it's lawful. If it was unlawful at the start, it remains unlawful at the end. And so repeating the activity cannot make it lawful in itself, and therefore in terms of the common law he finds against the Secretary of State, and that's strike two. Now, at at this time, towards the end of the judgment, Lord Camden makes a very famous, or provides a very famous quote. He says, "Our law holds the property of every man so sacred that no man can set his foot upon his neighbour's house without his leave. If he does, he is a trespasser, though he does no damage at all. If he will tread upon his neighbour's ground, he must justify it by law. We can safely say there is no law in this country to justify the defendants in what they have done. If there was, it would destroy all the comforts of society, for papers are often the dearest property that a man can have." So, no statutory authority, no common law authority. Lord Camden also dealt with the argument about the government needing such powers, and in effect the government arguing that it should be treated differently to the private citizens that Camden has just been referring to. And here he says this, he says, "With respect to the argument of state necessity, or a distinction that has been aimed at between state offences and others, the common law does not understand that kind of reasoning, nor do our books take notice of any such distinctions." And therefore what he's saying, if a private citizen needs lawful authority to act, then so does the state. And there is no argument of state necessity that can apply here. So that's strike three, and the Secretary of State is out and has lost the case. Or indeed, Carrington as defendant has lost the case because the Secretary of State lacks legal authority. Now that mention of state necessity towards the end is an interesting one, because it's always important in situations of war, national security, public emergency. And we've seen this in the UK in the post 9/11 era. And if you are interested in this regard, it's worth looking at the 2004 case of A and the Secretary of State for the Home Department, otherwise known as the Belmarsh case. And this case, if I haven't explained it here already, I will do in the near future, because it's such a key case. But if I return to the case of Entick, I come to an end with one of Lord Camden's most famous quotes from the judgment, where he says, "If it is law, it will be found in our books. If it is not to be found there, it is not law." And quite simply in this case, there was no law supporting the Secretary of State, and consequently there was no legal justification for the trespass. The Secretary of State was not above the law, and the case showed that he could be held to account in the ordinary courts of the land. And that, quite simply, is Dicey's second characteristic in action.